Okay, hello everyone. We're going to now take up the case of Cecil Laurey Smith versus State of Florida.
Good morning to the court and counsel. I'm Daniel Tibbet on behalf of Cecil Smith. The first issue is that the defendant in this case, before waiving Miranda, was asked the Miranda question, "Are you willing to answer my questions without having a lawyer present?" And his response was, "I can contact my attorney."
So let me jump right into it.
Sure.
3 questions. Number 1, was the defendant in fact referring to his right of counsel?
Yes.
Okay. Was that utterance a clear and bona fide question calling for an answer?
Yes.
Was it a rhetorical question?
No.
So if I recall, in your brief, you conceded that you didn't know if it was a statement or a question.
Correct. And I don't think it matters whether it's I can contact my attorney or I can contact my attorney. It's either way. What the case law says is if you're talking about a lawyer before you waive Miranda, the police have to make a good faith effort to follow up. And the police.
And did the cop do that?
No, Judge, because the officer, in response to the statement or question, "I can contact my lawyer," said nothing about a lawyer. He said, "Well, whenever you want, we can start talking. You can stop whenever you want. You can stop. Now sign here." And then the defendant even said, "Well, the officer was like, well, I didn't beat you up. I didn't threaten you." "No, you didn't. You just told me you had to talk to me."
Isn't this a factual issue that we review for abuse of discretion?
I'm sorry?
Isn't this a factual issue that we review for abuse of discretion?
It isn't what a factual issue? Whether
it was a question. I mean, I don't think that you contest that it could have been a statement or a question, right, in your initial brief?
It could have been a statement or a question, and the result is the same. And you look at the trial judge's...
What's our standard of review of this from the trial judge's
Yeah,
perspective?
it would be abuse of discretion, but it was, if you look at the judge's ruling, the problem in this case, quite frankly, is that the state, clearly from the transcript, did not understand the difference between what the law is pre-waiver and what the law is post-waiver, which is obviously much more favorable to the state.
Can we drill down on that? Exactly what is that difference?
The difference is post-waiver, the statement about an attorney has to be an unambiguous request for counsel. If it is an unambiguous request for counsel, then the police are required to cease questioning. If it is not an unambiguous request for counsel, the police aren't required to follow up. They can continue the questioning because the defendant's already been advised. The whole theory behind that is he's already been advised of these rights and he's waived them. But pre-waiver, if the defendant asks a question, and if you look at the Supreme Court's Almeida case, the question that the defendant asked in Almeida pre-waiver was, what good would an attorney do? So I would argue that's very similar to the question here of I can contact an attorney. He's considering invoking his right to counsel.
But he never did, though, did he?
No.
At no time did
just
he...
like of course not, because in every case where Miranda's an issue, the defendant has given a statement. But the fact that what all these cases say, Almeida specifically says, the reason for this is a defendant who has been ignored or overridden regarding the right will be reluctant to exercise their right, will not freely, feel free to exercise their right. And so based on that, they say if the police ignore the
How is this different from Florida versus Myers?
Is that case cited, Judge? I don't recall the case, I'm sorry.
It's a case from June 2024. Where after being taken to interview room and instructed to read the Miranda rights from a form and confirm he understood them, Myers mumbled, "I think I should have a lawyer." The officer responded that you're going to want to explain some things and you can start speaking, blah, blah, blah. Myers then asked, if I want a lawyer later on, can I get one? And the officer answered in the affirmative. Myers then agreed to waive his Miranda rights and sign the written waiver.
Okay. I don't think the case is cited, but based on the court, so I'm not familiar with it, but based on the court's recitation of the facts, that would be a genuine response to the question. The defendant asks, can I get a lawyer later? Yeah, you can get a lawyer later if you want, or you can start talking to me now and you can get a lawyer later. That's not what happened here. The detective said nothing about a lawyer. In response to a question about the lawyer, The judge didn't say, yeah, you could get a lawyer later. The judge didn't say, do you want a lawyer? The judge said,
The officer, I'm sorry.
I'm sorry, the officer, you're right.
Okay,
The detective.
the judge was there, we have other issues, but that's fine.
The detective did not say anything about a lawyer. That's the problem. And, that's what the case law says.
Can we talk about the motion to sever?
Sure. So the other issue is the motion to sever. The facts in this case are quite shocking and horrific, I'm sure, to a jury that, was walking in and hearing it. There was serious drugs, fentanyl, cocaine, strewn about this apartment, in the bedroom. In the bathroom, in the kitchen. There was also 3 young children, 2 to 4 years old, that were present in the apartment, but not in the, room together with the drugs, but there in the apartment. So he was charged with child neglect for exposing the children to the drugs, and which is a 3rd-degree felony, max 5 years.
But weren't the pictures that were introduced, showing baby bottles and other children items? So even if the 2 counts were severed, or the neglect or abuse accounts were not part of this, wouldn't it still have the same prejudicial effect? Because obviously, if you have baby bottles and diaper bags and things like that, there are children.
Well, I don't, the issue is the children are in the apartment at the time. When the police, come in, the only people there is the defendant and these 3 children. So the fact that there's children who live in the apartment, I think there was also some birthday cake that had been left on the counter from, days earlier when it was one of the kids' birthdays. Yes, there's children that live there. It's very different, I think, in terms of prejudice for a jury, hearing, okay, in a house where children live, the defendant has drugs out, versus he has the drugs all over the place while the kids are there, while the kids are just feet away in the next bedroom. That's the prejudice, is and if, although we obviously argue the statement shouldn't come in, one of the things that he talks about in the statement is, no, I kept all the drugs hidden outside. I didn't keep them inside only when I was bagging it up or something like that. So, he's trying to even say in that statement, what would sound better to a jury, that, I'm not exposing the kid. Yeah, I'm a drug dealer, but I'm not exposing the kids to the drugs.
Well, he did say that he was doing this for his kids, correct? To support his kids.
Yeah, it's a money-making enterprise. I don't recall if he said that specifically. But the point is, the prejudice is, it's very different. I do drugs at my house when my kids aren't there, or I sell drugs out of my house when the kids aren't there, or I package them up, versus I, expose these young children to the drugs.
How would you separate that evidence, though?
Because the kids, if you went to trial on the drug trafficking charge without the child neglect charges, the jury would never hear about the children being present in the apartment. It would be irrelevant, and it would be prejudicial without any probative value.
Hypothetical. The pictures with the drugs and the baby bottles, would y'all just redact the baby bottle out of the picture?
Potentially, but even when I don't know how feasible that would have been, and probably the state would have argued against that, but potentially it could have been redacted. Even if not redacted, again, it would show that kids, lived in the apartment. It would not show kids were present at the time that he had all these drugs strewn out when the SWAT team busted into the apartment. That is the prejudice. I think that pretty much summarizes my arguments. Does the court have any further questions? Okay, I'll reserve the rest of my time if there's any other
All right, thank you, Mr. Tibbet.
Good morning, Mayor. Please the court, Magali Rodriguez, on behalf of the state.
Can you speak up?
Yes. The response from the officer here to the statement question here was a clear, sufficient clarification as to the question.
Can we
statement.
back up just a little? So statement or question. Does the state have a position as to which one it is?
We are going by the ruling of the court, lower court. There was an observation. I can contact my lawyer. It's an ambiguous statement. So it's an ambiguous statement or inquiry. And it's the state position in this particular case that the response from the officer was sufficient enough to clarify that specific statement inquiry here. If it could have been worded differently, but the meaning behind whenever you want, we can start. Whenever you want, we can stop it. It implies that the defendant was in control of that interrogation. It implies that you can stop this interrogation now. You even can stop it to ask for a lawyer.
Okay, well, Smith told Officer Coleman before he signed the Miranda waiver, this is a quote, "You had to talk to me and I had to sign this," end quote. Does that indicate that Smith didn't understand that he could refuse the Miranda waiver?
I would disagree, Your Honor, because this is not the first time this defendant is being before had problems with the law.
Is that part of the record?
It is part of the record. You have priors here, and record page 89 of the transcripts on the motion to suppress, and you also have the prior records noted in the score sheet of the judgment and sentence in this case.
But don't we have to consider this individual situation kind of in a vacuum? I mean, we can't, this
Under
is
the
not akin
totality of
to a
circumstances.
sophisticated business person in a commercial transaction.
Under the totality of the circumstances here, Your Honor, you have that response from the officer when he asked that question about, if I'm referring to, I have to sign here because, you told me to sign here, and the response from the officer was a correct response. Again, it's a correct response to a question. All that is required is a honest, fair response. This
So you
case is
would
not
agree that he did not have to sign the form?
He didn't have to sign the form. He didn't have to sign the form if he didn't want it, but here in this specific case, we don't have anything saying that he hesitated, that he could have asked questions to the officer after receiving that clarification when he asked, when he made the statement about, I can contact my lawyer.
Was the officer obligated to tell him, no, you don't have to sign the form? In response to his statement, I have to sign the form.
The Florida Supreme Court has consistently stated, police officers are not legal advisors. All that is required under the Florida law is for them to give an honest and fair response to the question. And in this case, we have that. This case is not like Almeida or the rest of the cases where the question was ignored or there were games in the part of the officer. Here we have a clear clarification. He told him, we can, whenever you want, we can start. Whenever you want, we can stop.
Should we place any significance on the fact that Smith read the right to counsel and had already initialed the form by the time he made this statement?
That's one point that I wanted to bring, since you asked the question at the beginning, our opposing counsel, if we were referring to the specific right to counsel, and I believe Judge Booker brought the case State versus Meyer that I argued before this court. And State versus Meyer, the question was regarding the specific right of counsel. That's the first right. You have the right to remain silent, and you do not have to talk to me if you don't want to. Here we have already covered all those rights. The defendant has already initially every single right. And the right that we're dealing here is referred to every single right in the Miranda form. Knowing these rights, are you now willing to answer my questions without having a lawyer present? And the response from the officer here, whenever you want, we can start. Whenever you want, we can stop it. Sign here. And we have here, the officer was questioned regarding the sequencing in this case about sign here. And he said, by the time I said sign here, this defendant had already put his initial on the right, knowing this right. So it's the state position that this was.
So is that initial in and of itself a waiver of that right, or does the actual signature constitute the waiver?
It is in conjunction, Your Honor. It's not just, you just don't waive one right. The Miranda right has all the rights. And when you sign that form at the end, and if you have read, like in this case, the defendant read the rights out loud, asked the question, it got the response sufficient, and the state position is that this was sufficient. There is no case that says that it has to be in a specific express clarification, unless the state has not found that a case that states for that proposition. All that is required is for the officer to give a fair, honest response. And in this case, we did have that. So it's a state position that it was waived.
Let's say for the sake of argument that we find the trial judge did err in denying the motion to suppress. How have you carried your burden of proving beyond a reasonable doubt that the error did not contribute to the verdict?
It was harmless in this case, Your Honor, because this case was not only about the confession. We have independent evidence here, more than enough here. We have the defendant being found in the house with a lot of drugs, narcotics here. The officers, when went in to execute the warrant, he was found coming out of the bathroom. We have also linking this defendant, his phone, the photos from the phone that also display the living conditions of the house where the drugs were found. We have from the phone the text message about the narcotic cells that he was having. So we have more here than just a confession. And I think the state would submit that that was enough. Even if we put that confession to the side, it's harmless. It's more than enough to get this conviction of the drugs in this case. So unless the court has any questions regarding the other issues in this case, the state will rest on the brief for the issue 2 and 3. Thank you.
All right, thank you,
We ask
counsel.
that the convictions would be affirmed.
And rebuttal?
Okay, so I think the state said, we need to look at what the ruling of the lower court is, and I agree. The ruling of the lower court in this case was, I don't believe, on the motion to suppress, I don't believe that the discussion was actually a request for an attorney. And, that's correct, but it's the wrong standard. That's saying, I don't think this was an unambiguous waiver. This is what the defense lawyer did argue, below, and the state didn't understand, and unfortunately, apparently the trial judge didn't understand, that there's a different standard. They don't have to show an unambiguous waiver. That was the error. Discussion about there's no exception if somebody, I don't know if he has prior contact, I don't recall that, if he had prior contact with the law, but that has no relevance. There's no case that says that. The idea about if he initialed the right, when you initial the rights, the question on the form and verbally is, do you understand the right? Then the question at the end for the signature is, having, understood these rights, do you want to waive them, and if so, sign it. The waiver is the signature. It is not initialing the right. There is no case to the contrary on that.
Can you address harmless error?
Sure. The error is not harmless. There was, first of all, the state misstated the test by basically saying there's independent evidence of guilt. That's not the standard. The standard is, as Judge Lindsay correctly put it, I believe was asking the question, can the state meet their burden of showing beyond a reasonable doubt that the error did not affect the verdict? So in this case, this confession, of course, was the main evidence in the case. The state did not have him directly with the drugs. They had him in the apartment. They didn't have the drugs in his actual possession. There was other people who, that was the defense, was that the other adults had access to the apartment. The wife had access. He just happened to be there at the time. The state's rebuttal to that, of course, was the statement and the confession, which they hammered in closing. This is not a case where the court could possibly find harmless error on what the evidence was. Thank the court for your time.
In conclusion, you would like us?
In conclusion, we'd ask the court to reverse and remand the ruling on the motion to suppress or reverse for a new trial. For the motion to sever, it would just require a new trial on drug trafficking without the child neglect charge.
All right, thank you both.